Hello friends, greetings from Mukesh Patel. Today we are going to delve into a very absorbing topic of reassessment. Reopening. So many controversies surrounding that since the new scheme for reopening of assessments came in from 2021. But then we are going to deal with closing of controversies in connection with reopening. A historic judgment came on 4th May 2022 from the Apex Court when the Honorable Supreme Court in the case of Ashish Agarwal explained, analyzed and laid down several concepts in connection with the new scheme for reopening of assessments. Almost 2 years later, on 3rd May 2024, we have had another landmark pronouncement coming from the Honorable Bombay High Court in the case of Hexaware Technologies. An 87-page judgment pronounced by the Honorable Bench of Honorable Mr. Justice K.R. Sriram and Dr. Neela Gokhale has provided some startling insights into some issues which were probably not even dealt with before. And therefore, I have called this analysis as a triple-layered protection for taxpayers with reference to so many controversial issues surrounding the reopening of assessments and the litigation that has been proliferating around it. In this in-depth analysis of the Bombay High Court decision, we are going to deal with 3 principles that have been discussed and analyzed threadbare by the Honorable Court. 3 principles which often occur in so many cases where reopening of assessment has come to be challenged in a writ petition before a High Court. The first and most interesting issue, though not a virgin issue, it has been discussed several times, but then there have been decisions for and against this proposition. When a taxpayer approaches the court with a writ, one of the common defenses or objections taken by the Income Tax Department is that the taxpayer has an alternate remedy. He can always plead his case on merits before the assessing officer because the notice for reopening, the order under section 148 capital A and even the proceedings to follow, they are not final. The assessment is yet to take place on merits. But then the court has in this decision very categorically laid down that the department's defense or objection in relation to alternate remedy cannot survive, particularly in cases where a taxpayer has challenged the jurisdictional conditions prescribed under the various sections related to reopening of assessment, be it section 147, 148, 148A, 149, even 151 and 151A, which deal with a number of procedural issues. And therefore, what has to be kept in mind is that merely because alternate remedy is available does not mean that a taxpayer cannot pursue his writ. I think this very important aspect has been dealt with in this decision, and we shall also analyze it further as we go ahead. The second important principle that has been propounded by the Honorable Bombay High Court, in fact it's an issue which perhaps has come up for the first time before any High Court, and Bombay High Court decision is indeed the first of its kind dealing with the interpretation of the provisions of section 149(1) into bracket small b in regard to the 3 years period of limitation for issue of notice for reopening. Now it is commonly known that what happens in a case where the amount of alleged escapement is rupees 50 lakhs or more, almost mechanically, in a very large number of cases it has been seen, assessing officers issue notice even for a period of up to 10 years, because 3 to 10 years window is where the alleged escapement is rupees 50 lakhs or more. For the 3-year window, we have a provision that the amount has to be less than 50 lakhs. Now, we need to understand and appreciate the provisions of section 149(1)(a) and (b), because 149(1)(a) lays down the proposition that the reopening can be done within a period of 3 years. That's the standard proposition. 149(1)(b) says that the reopening of assessment beyond 3 years cannot be done unless and until certain prescribed conditions are fulfilled. And what are these conditions? Take a look at the screen as well. The conditions are: the assessing officer has in his possession books of account, documents or evidence revealing escapement of income. The next, such escapement is represented in the form of either of these three. 1, an asset. 2, expenditure in respect of transaction or in relation to an event or occasion. Or 3, an entry or entries in the books of accounts. And obviously, the most important condition is the amount of such income which has escaped assessment is rupees 50 lakhs or more. Now there is an explanation to section 149 which has defined asset, because any asset beyond 50 lakhs of rupees is not automatically attracted in the 10-year net. The explanation says, for purposes of section 149, asset shall include 1, immovable property being land or building or both, shares and securities, loans and advances, and deposit in bank account. So having understood these provisions of 149(1)(b), what has the Bombay High Court held while interpreting these provisions? The Bombay High Court has categorically held that the question of correctness of a taxpayer's legal claim for deduction under the provisions of the Act cannot represent escapement of income in the form of an asset. This is a very important provision in the context of 149(1)(b), because in the case before the Bombay High Court in Hexaware Industries, the controversy related to the claim for deduction under section 80JJAA to the tune of over 6.5 crores of rupees. It was more than 50 lakhs, but the High Court said that the question, this is a legal claim. This is not an asset. This is only a legal claim for deduction, and therefore if the department is disputing such legal claim, it will not attract the added period beyond 3 years and get into the 10-year window net. Moreover, the court also said that an alleged claim of disallowance of deduction can never fall under the category of expenditure in relation to an event or an entry in the books of accounts as prescribed under section 149. So when there is a disallowance of deduction, it neither falls in the category of asset or expenditure or even book entry. Now friends, stretching this logical ratio of this decision, let me try to analyze and explain from my own point of view. This, bear with me, is not what the High Court has said, but based on a logical interpretation of the ratio as laid down by the Bombay High Court, I believe it should be possible for a taxpayer to contend in any writ before the High Court that reopening beyond 3 years, even involving alleged escapement of income of rupees 50 lakhs or more, certainly cannot be invoked in any of the following instances. Disallowance of any expenditure, say for example under section 14A in regard to determination of disallowance of expenditure earned out of exempt income, or section 37 where certain expenditure is in dispute, whether it is business expenditure or otherwise, section 40 small a, or even for that matter 40 capital A, which are all effectively disallowances, or section 43B, they are all disallowances of expenditure. But certainly, in my respectful submission, it is neither an asset nor any expenditure for event or occasion or a book entry as contemplated within the provisions of this section. And I'll try to support my view not just as a view alone, but also with the legislative intention very shortly. Friends, the next point is, take for example, there is a disallowance of any claim for depreciation under section 32 or weighted deduction under section 35. See, we often come across cases where the department says we will not allow depreciation on goodwill or on depreciation on a particular asset. Now, depreciation certainly is not an asset. It is not even a book entry for that matter. And it is not an expenditure for an event or occasion. So, these kind of expenses, 32, 35, weighted deductions, scientific research, etc., they may run into crores of rupees. But if 3 years have passed, I believe the department would have no ground to delve into the realm of reopening in such a case. Disallowance of any deductions claimed under Chapter 6A. This was precisely what was there before the Honorable Bombay High Court. It was a deduction under Section 80 JJA. You could have several such deductions, Section 80IA, IB, IC, ID, IE, or for that matter it could be 80G, N number, 80P, N number of deductions. Even if these deductions are more than rupees 50 lakhs, but if 3 years have passed, they cannot be disturbed within the scope of the provisions of Section 149(1)(b). Very interestingly, the next is dispute in regard to determination of receipts or expenditure being in the nature of capital or revenue. The taxpayer contends that this income is a capital receipt. The department says no, this is a revenue receipt, or vice versa, capital or revenue expenditure. Now, just because there is a controversy or dispute in regard to the nature of the receipt or expenditure being capital or revenue, I think it will not fall in any of these three categories, and therefore there can be no reopening. My friends, you may ask me, then when can reopening beyond 3 years be invoked? Well, if you take a logical analysis of the interpretation of these provisions, I think it should be possible to contend that reopening beyond 3 years can effectively be invoked in instances where taxability has been provided under section 115 BBE, because each of these three will fall under these categories. Say unexplained cash credits under 68, book entries. Unexplained investments or monies under 69, 69A, 69B, clearly an asset. Unexplained expenditure under 69C, an expenditure for an event or occasion. You have gone for foreign travel, you've had marriage expenditure, wherever. So 68, 69, 69A, B, C, these are classically the cases where the department focuses on tax evasion, countering and combating tax evasion, and has under section 115 BBE even provided for almost a hefty tax rate and penalty of up to 84%, as we are all familiar. Let me try to support my own view and logically what the Bombay High Court has also decided by the legislative intent for the new scheme of reassessment. Now kindly take a look at the Finance Minister's budget speech of 2021, and I would like to quote these 3 paragraphs which are on the screen. She said, Honorable Speaker, presently an assessment can be reopened up to 6 years. The provisions as were prevalent until 2021. And in serious tax fraud cases for up to 10 years. As a result, taxpayers have to remain under uncertainty for a long time. So with a view to simplify and create an environment of ease of business, the FM's focus was, she said, I therefore propose to reduce this time limit for reopening of assessment to 3 years from the present 6 years. Kindly appreciate this. What was the logic for bringing it down to 3 years from 6 years? And why take 6 years to 10 years? Because she said, in serious tax evasion cases too, but they have to be serious tax evasion cases, only where there is evidence of concealment of income, not just escapement of income in a mechanical way of an amount of rupees 50 lakhs. But as I said, once you talk of 68, 69, 69 ABC, etc., it is clear evidence of concealment of income of rupees 50 lakhs or more in a year. Can the reassessment be reopened up to 10 years? So in 2021, when these new provisions were introduced, what was the objective? For routine cases, make the life of taxpayers simple. Bring down the reopening from 6 years, or there was even a 4-year provision, just to 3 years, and also stretch those extreme cases of tax evasion beyond 6 years and take them up to 10 years. So I think if we look at the legislative intent also, the limitation has sought to be very fairly, logically and absorbingly interpreted by the Honorable Bombay High Court. I think there can be no debate or controversy about it. If the matter has to go to the Apex Court also, I am sure the Apex Court would be more than pleased to give its seal of authority and stamp. The third principle, because I said that triple layer of protection, any one of these 3 principles, these are most commonly coming across, the controversies which we see to reopening. The third point is, in fact, as we know, under the old scheme of reassessment, there were n number of decisions of the Supreme Court, right up to Calvinator India, etc., talking about change of opinion. that there can be no reopening on mere change of opinion. When the new scheme came in, it was being proposed, or it was sought to be argued, that now the change of opinion theory will be given a go by. But friends, the Honorable Bombay High Court has again very authentically said that concept of change of opinion, what is it? It is an inbuilt test to check abuse of power by the assessing officer. It also syncs with the legislative intention. The assessing officer, having earlier allowed claim for deduction, later proposal for disallowance is a clear change of opinion. In the very case of Hexaware Industries before it, the court said that, well, in the preceding years, this deduction under section 80JJA was allowed. All conditions were looked into, and having once allowed it in the earlier year, now in the subsequent year, it is a matter of logical corollary that it is to be continued to be allowed. You are disputing that 80JJA claim is not allowable. This is not doable. So they said that change of opinion or review of the original assessment order is not permissible even under the new provisions. Friends, kindly bear this in mind. Change of opinion can never be a basis for reopening, was a settled proposition of law for almost ages together. It was being argued that under the new scheme now it may not hold ground. But here the Bombay High Court has very authoritatively said that even under the new provisions, the change of opinion philosophy will continue with as much authority. So it finally said that reassessment proceedings initiated on the basis of a mere change of opinion is invalid and without jurisdiction. Well, friends, that brings me to the end of this presentation. And as I mentioned, by a sheer coincidence, almost after a gap of 2 years, tax professionals and even learned taxpayers will have an occasion for very meaningful academic discussion. In May 2022, it was all about the Union of India versus Ashish Agarwal. In May 2024, in fact, this decision was kept CAV for over 2 weeks. And as I mentioned, it has run into an epoch-making 87-page judgment, which in fact is going to be a path-breaking judgment, creating milestones into this entire realm of very important and interesting subject of reopening of assessment. Let us hope this effort of the High Court will help in closing controversies, will perhaps guide the department, giving them more wisdom not to use this tool, where not required. Perhaps even try to look into the legislative intent of the provisions of the new scheme. And we only sincerely hope that it will mean and lead to greater ease of business, which of course is the dream of one and all, including this government and the Honorable Prime Minister. Thank you.